Hi everyone, before we start the roleplay, let us know a little bit about feature and chatter. Do you know what is feature and chatter?
Hi, I'm Sister.
Hi, I'm Chatter.
We live on the same land. What's the difference between both of us? Look at this.
Mixture is something that's attached to the land. Look at her, she just snapped off in one place and we thought it's very cool. While I can easily move around this land. I am considered as movable property.
The example of myself are trees, beds, and this land. And the example of Chatter is
Stand mirror. While we must know on how to distinguish between features and chatter, it is because it will affect the ownership of the item. From this, I hope you might get a clear view on the differences between both of them. Now, let us watch the roleplay.
enjoy!
The owner of the printing, and the offset print also was belong to me as we agreed on the hire purchase agreement. Look, in this charity document, show that the machine which is affect to the land by ball is a fixture, and this is also the security to me actually. So this means that the machine is belong to me. But the total sum of the agreement is 289,203.19 cents, and you have not paid 57,443.19 cents. So it's mean that the offset printing machine was still mine. Yes, I'm not paid 57,000 ringgit, but in the charter document stated that if I sign this document, that's mean all the things that's attached to the land belongs to me, include the offset printing machine. No, I still the owner of the offset printing machine because you have not paid 57,000.
NANI?!
We see in the court.
This is an appeal from the Senior Assistant Registrar Teacher that an offset printing machine be released to the second objectors MIMD instead of the first objectors EAD. If both counsel are ready, you may start your argument. May I begin, Your Honor?
Yes, please. That's all right.
Your Honor, we, representing EAC, come before this honorable court to assert our rightful claim to ownership of the machine, which is an offset printing machine. Our basis for ownership rests on a valid hire purchase agreement, the terms of which stipulate that a balance of $57,443.19 remains unpaid by MINB. Due to the existence of the hire purchase agreement, MINB cannot be deemed the rightful owners of the machine. The essence of this argument lies in the principles of Nemo that ought not have it. One cannot give what they do not have. In this case, MINB cannot acquire what does not belong to the defendant. Additionally, there is no evidence that Ibrahim bin Medan has a connection to defendants.
Counsel, please enlighten the court on who is Ibrahim bin Medan in this case.
Thank you for the question, Your Honor. Ibrahim bin Medan was the charger of the land which has been identified as a party to this transaction. However, there is no evidence has been proffered to establish his relationship with defendants. This lack of disclosure raises a significant legal point that what is annexed to the land is not necessarily a fixed rate. Therefore, the machine cannot be treated as a fixture under the terms of the hire purchase agreement, and it remains a chattel. Your Honor, since the property that has been charged to MINB is actually Ibrahim bin Medan's property rather than the defendant's, MINB is unable to obtain anything that does not belong to the defendants. Therefore, the hire purchase agreement remains in force, whereby EAC retains ownership of the machine. We respectfully request the court's careful consideration of these arguments in determining the true ownership of the machine in question. That's all, Your Honor.
Counsel, you may start your argument whenever you're ready.
MashaAllah, Your Honor. We are representing MINB consent to assert its right as legal mortgage based on a charging document. The machine is affixed to the floor on the ground of the premises by both. Therefore, the machine is clearly a fixture and formed as a part of the land. As stated under Section 5 of National Land Code, which defines land to include all things that attach to the earth or permanently fastened to anything attached to earth, whether on or below the surface, Your Honor.
Counsel, can you provide additional evidence or legal precedent that support your claim that the machine qualifies as a fixture?
Yes, Your Honor. The additional authority is that the judge in the case of Holland and Hudson quotes that anything that affixed to the land even slightly is to be considered as part of the land, unless it is intended to continue as a chattel. Based on this case, the machinery that is affixed to the floor by bolts is a fixture that is included as part of the land. Therefore, that's all the argument from the MINB side. Therefore, we respectfully request the court's careful consideration of this argument in determining the true ownership of the machine in the question in favor of MINB. That's all, Your Honor.
Okay. Based on the argument from both counsel from EAC and MINB, the argument raised by the EAC is not relevant. Consider who is the actual charger of the land. The land has been legally judged to the MINB, and MINB has all the rights of the chargee as stipulated in the charge agreement. The most important thing is the machine affixed to the floor and ground of the defendant premises by both, which fall under the character of fixture under Section 5 of the NLC. Although the counsel for EAC stated that the authorities referred by counsel for MINB relate to a mortgage is different from a charge, I would like to highlight that the machine is fixture and the authority must be the same for the land which is mortgage or charge. After considering the argument by both counsel, the senior assistant registrar was right in deciding that MINB had a prior claim as against EAC to the machine. Therefore, the court dismissed the appeal with cause. The court is adjourned.
Rubber estate, you know?
I also heard about that.
Really? What happened?
Calm down. So what issue?
The issue is, can you imagine that the rubber estate had already signed the contract And out of sudden, they want the rubber machine back. Like, wait,
Oh my.
they didn't even know. No. Wait, I have the picture. Wait.
Oh yeah, yeah.
Wait, by the This one? Oh my god.
Just this machine.
Yes,
Why?
they want it back.
Oh my god, that's awful.
Isn't it?
Oh my god, guys. Guys.
Wait a second.
Relax. You know what?
What?
Someone told me that he also gave his possession to Jetty.
Oh my god!
Can the Malay Consolidated Rubber Estate took possession for all his machine?
Yes, I think they brought this case to the court.
Huh? They brought this case to the court?
Yes.
I wonder who will win.
Me too.
Yes, right?
I'm so curious.
Alright.
All of you may be seated. This is an appeal case between Goh Chong Hin and SRMS Lachmanan Chetty SJ Appellant and the Consolidated Malay Rubber Estate Limited as respondent. If both counsel are ready, you may start your argument.
Yes, Your Honor. In the case of Goh Chong Hin and the Consolidated Malay Rubber Estate Limited on 26 April 1921, Goh Chong Hin executed a charge in favor of Lachmanan Chetty as a chargee, which includes his building and factory. On 25th June 1921, Goh Chong Hin executed a bill of sale over the machinery in the factory to the Consolidated Malay Rubber Estate. And on 25th October 1923, Lachmanan Chetty, by the consent of Goh Chong Hin, took possession of the land and the factory. On 31st December 1923, the Consolidated Malay Rubber Estate Limited applied for order to seize and sell the machinery by virtue of the bill of sale.
Counsel, since Mr. Goh Chong Hin is with you, may I seek for Mr. Goh Chong Hin confirmation on the accuracy of these facts?
Yes, Your Honor. I indeed had charged my land including buildings and factory upon 5 pieces of land to Lachmanan. Then on 25 June 1921, I had executed the bill of sale assigning to the respondent over the machinery includes 1 suction gas engines, 1 universal scrap washer, 3 shaping machines and 4 crimping machines which are affixed to land with nuts and bolts in the factory. I then gave my consent for Lachmanan as a chargee to take possession of the rubber estates and factory. I hereby claim that I have the power as a chargee in allowing Lachmanan to claim the possession of land, and such possession still continues. As applying in the case of Mother and Fraser, the presumption becomes almost superable, and I as a chargee and freeholder set up the machinery with the object of enhancing the value and utility of the land for the purpose for which existed as a rubber estate. Even if the machinery was set up after the date of the charge, it nevertheless accrued to the land and become part of second appellant's security. That's all on behalf of first appellants. Much obliged.
You may take a seat and please continue your argument, counsel.
May I start my argument, Your Honor?
Yes, please.
Your Honor, my client, who is Lachmanan as a chargee, hereby oppose the idea of the respondent applying to seize and sell the said machinery. We want to raise an objection that the machinery is a fixture which is part of the land covered by my client. English law can be applied in this matter where the machinery in dispute must be held to be fixtures and part of the land. The said machinery is affixed to the land by bolts and nuts and sunken in the soil. It is initiated in the case of Holland and Hodgson that where an article is affixed by the owner of the fee, though only affixed by bolts and screws, it is to be considered part of the land. Your Honour, that's all on behalf of the appellants. Much obliged.
Thank you, appellant. We move to our respondent. You may start your argument whenever you're ready.
May I start my argument, Your Honour?
Yes, please.
Much obliged. Your Honour, we hereby argue that the machine constitutes a chattel as follows. In the case of Kemby, the land judge in the case held that by custom, the usual Malay plank house built open brick piers or pillars with foundations let into the soil is held to be chattel and movable property. Furthermore, my client has right to sell the machinery by virtue of bill of sale. Much obliged.
Based on the argument from both counsel, I would like to highlight our registration title, Enactment Section 2, that interpret land to include things attached to the earth or permanently fastened to anything attached to the earth. For the matter of Tiambi case raised by the respondent, it does not prove any widening principle of English law as to fixtures. It was unreasonable to be mentioned to respondent contention if you were to pick a case where English decision as to custom as affecting fixtures. There is this notable case of Wake and Hall. The judgment in this case is clear that the general rule is whatever annexed to the land becomes part of it, if it was intended to be permanent. Therefore, I have come to a decision that it is necessary to establish definite principle as a safer and more convenient way. As in the case of Wake and Hall, the court now held that the machinery is a fixture and immovable property. Therefore, I agree that this appeal should be allowed.